is, well, he's not like the kids over at the Welsh News Network. He's not a.
I don't. No. No. I told you I wanted to vacuum and dust this room. No. Get out.
Hang on one second. He's not a.
I don't. No. No. I told you I wanted to vacuum and dust this room. No. Get out.
Hang on one second. He's not a.
I don't. No. No. I told you I wanted to vacuum and dust this room. No. Get out.
Hang on one second.
All right. Good freaking morning. Good morning. Actually, we're going to start here. So the first thing we're going to talk about is DeCastro versus Wagner. It's an oldie but a goodie. It has been appealed. Obviously, this is back from October 5th. In this particular case, nothing has really happened. The signed notice of appeal was filed on the 16th, and the Ironton attorneys have made an appearance. Lawrence County. Yeah, so maybe not the Ironton, but the Lawrence County attorneys have made an appearance. So the next step, hey, buddy, the next step is that, in theory, Chile will prepare and file a appellant's opening brief, and in which he needs to lay out the facts and the law. And by facts, I don't mean conclusions, but actual facts, which he is incapable of doing. And then he'll have to lay out the law as it applies to those facts, and he'll have to show where the court erred, and he won't be able to do that. So this is pretty much a doomed session to start with, but that's where it's at, and we'll get to look and laugh along the way. In DeCastro versus the LVMPD, nothing really has happened there. In Wallace versus LVMPD, you will notice that Wallace was supposed to file a notice clarifying if he is dismissing all the claims against all the defendants, or only dismissing against the individual defendants. That was due by November 3rd, 2023. The clerk was to do a status check on November 3rd, 2023. There is nothing there. So whether or not he actually filed one in time, I don't know. Chile's normal modus operandi is to file late and ask for forgiveness. So we will see if he does that. And I'm going to do one thing real quick. All right. Perfect. And then finally, this is the meat and potatoes of today. The meat and potatoes. So when we left, Springer versus the 7th Judicial District Court of New Mexico, there are 3 motions pending. There is a motion to dismiss that is not fully briefed yet. So we have to wait to see how that works out. Then there was a motion to recuse the judge that was fully briefed. We will go over that today. And there was the motion for the stay pending the appeal, which was fully briefed. And so we'll go over that today. Now, I hope that James Allen Springer is not paying his attorney. I hope that his attorney is doing this on a contingency basis, i.e., getting paid only upon a favorable outcome, because his attorney is doing a pure shit job. Now, I get a lot of people who think that I believe that I am that my shit doesn't stink. Now, I don't claim that at all. But there's a real problem. There's a real problem if a first-year family law attorney out of California can spot all the problems in your fucking briefs and you can't. And then have the judge come back and say, well, this first-year family law attorney fucking nailed it. That's a real problem. When I start to be wrong, like substantively wrong, substantially wrong, then I think I'll be more amenable to criticisms that my hubris has taken the lead. That I am. Well, thank you, insane one. But until then, it's not. It's not that I have an overinflated sense of ego. It's that I'm fucking right, and that's a problem that people seemingly can't really wrap their heads around. I was right all the way down the DeCastro versus Wagner route. I called things ahead of time. I am a professional, as J5 says, a professional peruser of briefs or boxers. I mean, I don't judge. So yeah. So the first thing we'll do is we'll go over the order denying the motion that the judge recused herself. Now, obviously, I called that he's going to lose. He's going to lose hard on this one. So we will see what the judge says. This matter is before the court on Springer's motion for the judge to recuse herself from all proceedings and to reassign the case pursuant to 28 USC 144. There's been no response and a reply. Having considered the party's submission of the record and the relevant law, the court denies the motion. Who could have fucking seen that coming? On June 9th, 2023, plaintiff filed a complaint for declaratory and injunctive relief alleging violations of his rights under the First and 14th Amendments of the United States Constitution and Article 2, Sections 17, 18, and 23 of the New Mexico Constitution. Plaintiff's claims arise out of the interactions between plaintiff and personnel at New Mexico's 7th Judicial District Court, which resulted in an amended administrative order barring plaintiff from entering courthouses within the 7th Judicial District unless appearing for a hearing or having specific court business, in which cases plaintiff shall be escorted and accompanied by law enforcement while in any of the buildings. Plaintiff incorporated into his complaint a request for a temporary restraining order, TRO. The case was assigned to United States District Judge Kia Riggs, who issued an order directing service and setting a briefing schedule on the request for TRO. The order required defendants to respond to the request for TRO within 14 days of service and Judge Riggs' order. Plaintiff filed returns of service indicating that defendants were served with summons and complaint on June 9th, 2023. On June 14th, 2023, the case was reassigned to the undersigned United States District Judge. On July 19th, plaintiffs filed a certificate of service indicating that Judge Riggs's order directing service and setting a briefing schedule was served upon the 7th Judicial Court, Circuit Court, via a process server on July 13th, 2023, and was emailed to the proposed text email address for defendant Mercedes Murphy, Chief Judge of the 7th Judicial District Court on June 21, 2023. On August 7th, 2023, plaintiff filed for an application for clerk's entry of default as to particular defendants. Despite its title, the application appears to request entry of default against all defendants. It's amateur hour like this that really makes me concerned that oh, you can't see any of this? Oh, well, there you go. Thank you, Mary Smith. Thank you for being the one person paying attention. The rest of the class will have to stay after school for detention. So it's this amateur hour that really makes me concerned that that Springer's attorney is not the expert, the the experienced attorney that he claims he is. Oh yeah, everybody's listening now. Right, Michelle, you were listening. All right, hold on. Let me look at one thing here. Let me look up this dude. Let's see. Because he has a CV that looks somewhat interesting. That looks like he knows a thing or two about a thing or two. A. Blair Dunn, Google search. Right, Ubu, right. Oh yeah, I can't see his Twitter because I don't have a Twitter account. That's like the stupidest thing ever. You can't see Twitter anymore without having a Twitter account. Or X. You can't see X anymore. It's twitter.com, but you can't see X anymore. God, what a Oh, here we go. I never saw this before. Libertarian, okay. He ran for Attorney General of New Mexico. He lost 4.8% of the vote. Ouchie. Ouchie. Oof. That was a big oof. The guinea fowl are near me. You're going to get to enjoy their sweet serenades. Yep. Thanks, guys. He's a 6'9" judicial gladiator. Traeger Hall of Flamer. Live free, semper fidelis tyrannus. A federal lawsuit against Grisham. So Blair Dunn wrote this? So it looks like he sued Governor Michelle Grisham over the COOF requirement that you get a thingy. Hold on, let me check this out. How would I find that? New Mexico Court of Appeals. All right, let's see if we can't find the New Mexico Court of Appeals. Mexico Court of Appeals. Sorry for dragging everybody through all this. Formal opinions. Reload. Formal opinions. Let's see. Enjoy. Scholar.google.com. Case law select courts. New Mexico. God damn. I get it. Stop it. Hey. Had to clap at them. Oh, those aren't chickens. Those aren't chickens. Those are guinea fowl. And if anybody ever tries to convince you to get guinea fowl, all right. Oh, you can't see this. Hey, hey, go chase them or something. Oh, I trained you not to chase them. Huh. That's all we got. Okay, well, let's go to Pacer. Let's go to court listener. Court list. All right. It's normally not that bad, Michelle. But they don't normally come into the backyard. They're normally out front or like on the front lawn or. Oh my God. Hello, Chris. All right. Let's see. We're going to do the recap archive. We're going to do paste as plain text. We're going to search. And survey says. But anyway, if anybody ever tries to convince you to get guinea fowl, I suggest you not get them unless hold on. It wouldn't be in recap. I wish I could find more on this. Let's see if I can't narrow this down a little bit. Cited by 0. That's all we get? Man. Oh, you can see this. So it doesn't, I can't find anything on it. I don't know if you won or lost on this one. But if we go back to this one, it looks like the restraining order was denied and then it kind of just petered out. So I'm not entirely sure. this is he appeals. When was this? This was 2018. Our boy Blair Dunn appealed a district court order awarding defendant Leela Dunn attorney's fees in this domestic relations case. What's going on here? What's going on here? And he lost. Boy, this Blair Dunn does not have a winning record. Show me where. I don't want to use. I don't filed the complaint known as quitantum. The state's blah blah blah. Very narrow and very rare. It's an opportunistic and parasitic suit, says Assistant Attorney General. Huh. What in the hell? I don't want you. What else do we got here? There's a cease and desist. Federal judge slaps New Mexico attorney in a bail reform lawsuit. Blair Dunn was ordered to pay back the state for filing a, quote, frivolous lawsuit, end quote. This is who fucking Springer chose. Oh my God. So after Blair Dunn gets essentially sanctioned. He gets essentially sanctioned. These attorney fees are because he filed a frivolous lawsuit. So he has to repay the state's costs because he filed a, quote, frivolous, end quote, lawsuit. The court found that the lawsuit was frivolous. This dude has filed a frivolous fucking lawsuit. And that's who Springer picked. Now, the frivolous lawsuit was because you can't sue a judge for money damages. What's this motherfucker doing in Springer versus the 7th Judicial District Court? He's suing the motherfuckers, the judges, for money damages. He's suing them for money damages. What was the first thing I said? I was like, oh, you're not going to fucking get any money out of the judges. I mean, maybe he can get money out of the 7th Judicial District Court itself. Maybe he can get money out of the clerks, plural. So my point is that Springer's attorney has been filing frivolous fucking motions, like blatantly wrong, like clearly frivolous motions. The motion to recuse was clearly frivolous. The motion to have the injunction pending the appeal was clearly frivolous. Now the judge in this case doesn't hold that, but like if a first-year family law attorney can look at it and say this shit isn't going to fly, like so when I went over his motion for the appeal, when I first went over that motion, it was at the end of the live stream. I remember that, and I looked at it. I'm like, he's just going to lose. Like he's just going to lose on this. Like I didn't even do an analysis. I was like, he's just going to lose. When I went over his reply, I was like, okay, like here's a problem. Like you're using the federal rule of appellate procedure to try to do this appeal in the district court. You're citing a case to support your proposition that is dealing with a federal rule of appellate procedure motion filed in the appellate court. Like it's just so many levels of wrong that it's hard for me to wrap my head around how this guy can be this fucking wrong. He's just this fucking wrong. And he holds himself out to be a practiced federal litigator. He's a founding partner of a firm that's focused on federal advocacy. Now, maybe he's out of his lane. Jesus fucking Christ. All right. Sorry about that. I chased him away a little bit. Hopefully they don't come right back. God damn, those birds are annoying as fuck. Springer's not stupid. How can an attorney not know that? I don't fucking know. Like, that's why I'm so like back with Wish, right? I was very critical of him because he's an attorney. With all of the attorneys, I'm actually more critical of them because they should fucking know better. If you're not smarter than a first-year family law attorney out of California, then you've got some real fucking problems. But this guy alleges that he is focused on federal advocacy. Now, I get it. He's focused on federal advocacy for farmers and ranchers, but you should still have some of the basics. You should still have some of the basics. And this guy is just, I just don't get it. I just don't get it because he's flailing around like a retard. All right. Anyway, back to the order. On August 8, clerk entered a default against all defendants for failing to plead or otherwise defend in this action. On August 10, plaintiff filed a notice of completion of briefing, service, and additional information, quote, first notice of completion of briefing, end quote, to which he attached the declaration of James Springer. The Springer declaration, inter alia, states, inter alia, that, number one, plaintiff is, quote, familiar with the contents of the complaint and the motion for TRO and preliminary injunction, and I verify that they are true and correct to the best of my knowledge, end quote, and that he has, quote, never been obstructive with the business of the 7th Judicial District Court, end quote. The Springer Declaration also provides links to videos on plaintiff's YouTube channel of plaintiff's interactions with employees of the 7th Judicial District Court. 2 of the videos are no longer available. That's a real problem. Like, if you, as the plaintiff, are putting out videos and saying, this is a video of my interaction, and then you, as the plaintiff, make a video no longer available, that's a real problem. That's a real problem. Yes. Eamon Bundy's attorneys won, so maybe you should step that one back because his attorneys won. Put back a year or two in what? I'm not. I'm still a first-year family law attorney. That's terrible, right? Merb's Wild Kingdom. Yeah, I guess, man. It's just Merb's Barnyard Kingdom. Goddamn guinea fowl. I swear to God. But if you are holding out these links to these videos are part of my evidence, and then you make them not available to the court, then that's a real problem. And his attorney, Springer's attorney, should seriously have a talk with his client, or he should provide those videos to the court on a flash drive or something like that, so that he could take them down from the public if he doesn't want the public to see, without removing them from the ability of the court to view. Oh, Jesus, are they coming back? I swear to God. I might have to go inside. Because that's just getting ridiculous. It's not that bad when they're up front. Like, I can still hear, like, if I play back one of my recordings, I can still hear them out in the front yard in the recording. They're just so loud and obnoxious. And we only have 3 of them. Our neighbors, they're the ones who gave these to us. Our neighbors have like 30 or 40 of them. and they're dumb. They're dumb. They're probably the dumbest birds I've seen. They're dumber than turkeys, and turkeys are dumb, and they're dumber than chickens, and chickens are dumb. Like chickens are smarter than turkeys. Turkeys are smarter than guinea fowl. Yeah, that's only 3, Michelle. Like it's ridiculous. And our neighbors have like 30. And the only reason why they only have 30 is because they're so dumb they'll fly out in the middle of the road and get hit by cars all the time. But they breed like crazy. Oh. So yeah, you should not take down videos that you're using as evidence supporting your claims, because either it's spoliation of evidence or it's just going to irritate the court. On August 15th, 2023, do you describe yourself? I don't know what, as annoying? Sure. No, I should not try out. If we are going to do anything goose-like, I think I'd get a swan, because they're mean, but they'll protect flocks. So, yeah. I believe his time frame is coming up. Yeah. No, not chasing him. All right. So on August 15th, 2023, attorney Jay Delphin entered an appearance on behalf of all the defendants. On August 21, the court sua sponte ordered defendants to respond to the request for a TRO by September 5th and provided plaintiff until September 19th to file a reply. On September 5th, defendants filed a response to the request for a TRO and a notice of lodging media exhibits indicating they submitted a CD-ROM containing videos published on plaintiff's YouTube channel, ECF number 30. The clerk's office subsequently provided the CD-ROM to the undersigned judge's chambers. On September 19th, plaintiff filed a reply in support of his request for TRO. Also on September 19th, plaintiff filed a second notice of completion and briefing in which he incorporated by reference the first notice of completion of briefing and all attached exhibits therein. No, I am not a mob boss attorney. Yeah, once his appeal is rejected, he's done. Or once he loses his appeal, I should say. On September 21, the court entered an order denying plaintiff's request for a TRO preliminary injunction, finding that plaintiff had failed to satisfy his burden of establishing a substantial likelihood of success on the merits of his claims. Specifically, the court found that, quote, plaintiff's motion wholly failed to identify the elements of his causes of action, much less demonstrate a substantial likelihood that the facts of this case satisfy those elements, and, quote, failed to cite any legal authority supporting his claims, which is grounds alone for denying the motion. Wondering what Merb did to his neighbor to cause them to inflict him with those birds. My wife wanted them. They're 2 of them are white, and one of them is like a gray top with a white underside, so they're kind of pretty. And my wife and the neighbor's wife really get along well. They like each other. They exchange dishes. You know, like my wife will make a casserole. They'll make a, I don't know, peach cobbler or something, and, you know, swapperoo. So they get along well. My wife gave them a bunch of fertilized eggs and fertilized chicken eggs, because we helped them harvest the remains of their chickens. They were getting old and they weren't producing eggs, so we helped them harvest their chickens. And then my wife gave them a bunch of eggs that were fertilized. So, and it's just, you know, they just share. Sharing is caring. So it's not like they were doing anything mean. My wife wanted them because technically they're supposed to really help keep down snakes, and my wife is not a big fan of snakes. I don't particularly mind them, but they also will eat like ticks and things like that. So I don't know that the chickens don't eat ticks or anything like that. We don't have very many land bugs left in our yard. The flocks of chickens and whatnot. Yeah, the flocks of chickens do a pretty good job of keeping down all of the bugs. The court also stated incorrectly the plaintiff had failed to file an affidavit in support of his motion and unverified complaint. Also on September 21, no animals eat ticks. Opossums do. I know that. Guinea fowl are alleged to. I assume that the chickens do too. They'll eat pretty much anything that they can get in their mouth. My wife sounds like Leave It to Beaver. I have a pretty good life, dude. Like, I'm not gonna lie. Yeah, I'm not a real big fan of it myself. It's amazing how the prettiest things are the most annoying. Sometimes. That's why I'm annoying. Also on September 21, 2023, the court issued an order observing the defendant still had not responded to the complaint and requiring plaintiffs to 1, file a motion for default judgment, or 2, show cause why this case should not be dismissed for lack of prosecution. Also on September 21, plaintiff filed a, quote, expedited motion to reconsider the court's order denying his request for TRO preliminary injunction on the grounds the order erroneously found that he had failed to provide an affidavit in support of his request for a TRO preliminary injunction or verifying his complaint. I don't know what you're trying to say, but ticks have protein and birds and opossums like protein, so they'll eat them, I guess. Maybe that's not their preferred food, but they'll eat them. Therein, plaintiff admonished the court for overlooking his declaration because, 1, he had attached the declaration as an exhibit to his first notice of completion of briefing, and 2, had incorporated into a second notice of completion of briefing the exhibits attached in the first notice of completion of briefing. On September 22nd, 2023, the court entered an order granting, in part, plaintiff's expedited motion to reconsider, finding that plaintiff had, in fact, filed a declaration in support of his request for a TRO and complaint, and indicating that it would issue an amended order accounting for the declaration and omitting the offensive language. However, because the amendments did not alter the court's conclusion that plaintiff failed to carry his burden of establishing entitlement to a preliminary injunction, the court denied the motion to reconsider in all other aspects. You have to you probably have to buy her dinner to find out, I'd guess. I'm not going to spill her secrets. On September 22nd, 2023, the court entered an amended order denying plaintiff's request for a TRO preliminary injunction. On September 29th, the plaintiff filed this instant motion for recusal. On October 3rd, plaintiff's counsel filed a certificate of good faith saying the plaintiff's motion to disqualify Judge Strickland is made with the utmost deference and with all benefit of the doubt possible in good faith pursuant to 28 U.S.C. Section 144, citing United States versus Bray, 10th Circuit case. Defendants filed a response to the motion for recusal, ECF number 49, to which plaintiff filed a reply, ECF number 55. Discussion. Plaintiff seeks recusal of the undersigned judge pursuant to 28 U.S.C. Section 144 and 455A. She's a subscriber and she watches them, so I'm going to assume yes, but it's not really her place to tell me what I can or can't do with my free time. So whether she does or doesn't really change much in the long run. And then, although the introduction to plaintiff's motion requests recusal under Section 144 and 455A, its argument section limits its analysis to recusal under Section 144 and does not separately discuss recusal under Section 455A. Again, it's amateur hour, and the judge is pointing out how amateur hour this Blair Dunn guy is. Section 140, quote, oh, hold on a second. I skipped. The court will first address why recusal under Section 144 is unmerited, and then address why disqualification under Section 455A is improper. Recusal under Section 144. Pursuant to Section 144, whenever a party to any proceeding in a district court makes and files a timely, which the court doesn't address, insufficient affidavit that the judge before whom the matter is pending has a personal bias or prejudice either against him or in favor of any adverse party, such judge shall proceed no further therein, but another judge shall be assigned to hear such proceeding. The affidavit shall state the facts and reasons for the belief that bias or prejudice exists. A party may file only one such affidavit in any case. It shall be accompanied by a certificate of counsel stating that it is made in good faith. Section. Yes. I assume that it's still on tomorrow at, I think, 4 o'clock Pacific, so 7 o'clock Standard. I should be having a debate with Rogue Nation. I will be taking the position that the decision in Garland versus Price was erroneous, and he will be defending it. So that is allegedly what will happen. We will see. And these bastards are coming back. Hold on. Call Saul and disturb Merb. Okay. Okay, thanks. Is it on this channel? No, it will be on Rogue Nations, I believe. Should it be interesting? Well, I don't know. So Section 144 requires that where an affidavit of personal bias or prejudice is filed, the judge must cease to act in the case and proceed to determine the legal sufficiency of the affidavit. When considering the sufficiency of an affidavit filed under Section 144, the judge may not consider the truth of the facts alleged. The test for the affidavit's adequacy is whether it satisfies the requirement that the facts and reasons stated therein, quote, must give fair support to the charge of a bent, you little bastards, you better not be coming back. I swear to Christ. All right. I apologize about that. I've had to move inside. I can't take all of that screeching in my ear. So let's see. All right, we're going to proceed. The test for the affidavit's adequacy is whether it satisfies the requirement that the facts and reasons stated therein must give fair support to the charge of a bent of mind that may prevent or impede the impartiality of judgment. However, conclusions, rumors, beliefs, and opinions are not sufficient to form a basis for disqualification. To sustain disqualification under Section 144, there must be demonstrated bias and prejudice of the judge arising from a, quote, extrajudicial source. That means outside of the lawsuit, which renders his trial participation unfair and that it results in an opinion formed by the judge on the merits on some basis other than that learned from his participation in the case. The affidavit must state with required particularity the identifying facts of time, place, persons, occasion, and circumstances. Remember the example I gave you the last time when I went over, I think it was the, there's no sound? There should be sound. There should be sound. My mic is not showing muted. Go to live. Oh, people are saying I hear you. Good. All right. Okay. All right. So, yes, you want attention so bad. In the last time that I went over, I believe I was going over the reply. I gave the example of you could say that I saw the judge at a bar with, this judge at the bar with the opposing party, and they were buying drinks and laughing and having fun like they were old friends. That's the kind of thing that you would need to show, right? The affidavit is strictly construed against the affiant, and there is a substantial burden on the moving party to demonstrate the judge is not impartial. Here, the only possible allegation of bias asserted in plaintiff's affidavit appears in paragraph 8, which states in full, "It appears that despite filing and serving my case in mid-June," again, these are within the lawsuit, these are not extrajudicial, "as a result of the threat of criminal prosecution by defendants in this matter because I could not comply with requirements to have law enforcement escort me whenever I entered a court facility, blah, blah, blah. The defendants have refused to comply with the requirements of the court order and the rules of civil procedure, but rather than hold them to the same standard for those violations, the court has instead allowed them extra months worth of time." Again, not extrajudicial. It's within this lawsuit, including extensions of time they did not request, still within this lawsuit, and has not required them to explain why they are excused from following court orders or the rules, again, within this particular lawsuit. Instead, it is my understanding that court is requiring that I show cause why my case should not be dismissed for lack of prosecution. Again, this is not extrajudicial. This is within this lawsuit. In essence, explaining why I shouldn't suffer the loss of my constitutional freedoms because defendants have failed to follow court order to provide an answer to me, or an answer to my complaint as required by the rules as my attorneys have explained to me, which is really stupid because what the court was saying was to ask for a judgment protecting your constitutional rights. You've sued for your constitutional rights. So, I want to do this, and I want to do this, since I only have one screen right now, to make this a little bit easier on me. I don't necessarily want the guinea fowl to disperse. I just don't want them next to me. I want them to stay roughly in the yard. We have a fence around the entire perimeter that is sufficient to keep out things like coyotes and really any animal that isn't smart enough to climb over it. Any animal that's small enough to go through it's like 4x4 field fencing. any animal that's small enough to go through that 4x4, 4 inch by 4 inch square would be able to get through, but everything else would have to climb over or fly over or jump over. So, and then once they get inside, if they're big enough that they have to jump or fly over, then or climb over, then the dogs are going to notice them. So I want them to stay in the yard where they're relatively. What in the hell's going on? Why does it not see? Okay, fucking weird. I want the dogs to be able to protect them, so I don't want them to disperse too far. I don't want them to leave the yard. The court finds that plaintiff's affidavit is insufficient under Section 144 for several reasons. First, the affidavit fails to assert that the undersigned judge's alleged bias against plaintiff or in favor of defendants arises from extrajudicial source. Indeed, the affidavit fails to assert that the undersigned judge has any knowledge of plaintiff or defendants that was not learned from her participation in this case. For this reason alone, plaintiff's affidavit is insufficient. N.C. Davis affirming that the district judge's decision not to disqualify himself under Section 44 because plaintiff's assertions of bias all have their origin in judicial proceedings, and the decision was on the record made in the judicial proceedings. And then see also Winslow denied a motion to disqualify because the affidavit did not allege bias on an extrajudicial source. Paragraph 9 in his affidavit states, I specifically requested this matter upon these facts be reviewed by a different judge to examine if it may reasonably questioned that Judge Strickland has prejudice against me or bias towards defendants who are also judges or court personnel. That was number 9. Where was this? Where was footnote 9? Did I miss footnote 9? Was footnote 9 from the previous page? There's 4, 7. Is that just a continuation? That must be just a continuation of this. Okay. All right. Guinea fowl meat is moist, firmer and leaner than chicken meat, and has a slight gamey flavor. It has marginally more protein than chicken or turkey, roughly half the fat of chicken, and slightly ... Well, you can't make everybody happy all the time, unfortunately. Second, only the basis for disqualification reflected in plaintiff's affidavit are judicial rulings. Specifically, plaintiff appears to argue that one could infer that the undersigned judge is biased against plaintiff because she, number one, sua sponte, provided defendants an extension of the deadline to file or to respond to the request for ATRO after they entered an appearance, and two, ordered plaintiff to either file a motion for default judgment or show cause as to why the case should not be dismissed for lack of prosecution. But it has not required defendants to show cause for failure to comply with deadlines to respond to a request for TRO and complaint. However, quote, judicial rulings alone almost never constitute a valid basis for a bias or partiality motion. And plaintiff has not demonstrated the rulings above would meet an exception to that rule. Indeed, extending a filing deadline, quote, does not in and of itself demonstrate bias against, end quote, plaintiff. See Phrygia. The court finds this to be especially true where, as here, the filing is a response to a request for a temporary restraining order and or preliminary injunction. Quote, a preliminary injunction is an extraordinary remedy almost or never awarded as of right. A preliminary injunction is an extraordinary remedy never awarded as of right. In each case, courts, quote, must balance the competing claims of injury and must consider the effect on each party of the granting or withholding of the requested relief, end quote. As such, extending the deadline to respond to plaintiff's request for the extraordinary remedy of a TRO or preliminary injunction was entirely appropriate, does not give fair support to plaintiff's claim of bias, and is therefore insufficient to support plaintiff's request for recusal. Furthermore, ordering plaintiff to either file a motion for default judgment or show cause why the case should not be dismissed for lack of prosecution does not evidence bias. It was simply the court's way of attempting to get plaintiff's counsel to do what he should have done several weeks prior. And again, I'm not trying to be a dick. I'm just trying to, this Blair Dunn guy is not doing what a good attorney would do. I'm not going to say he's a bad attorney. I'm just going to say that he's not at all doing what a good attorney would do. A good attorney would have filed that motion for default judgment. Like, I've worked with multiple attorneys, and neither they nor I would ever move for a default without also moving for a default judgment at the same time. They're part and parcel. The default is essentially meaningless. I mean, the only time I would not move for a default judgment with the default is if only one defendant out of multiple defendants has defaulted, in which case, as to that defendant, I would just move for a default. And then, of course, I'd have to proceed with the other defendants. That's, for example, that's what's happening in the DeCastro versus whatever Kate's last name is that I forget. But in the California case where DeCastro sued Kate as well as Blue Bacon, Kate defaulted. So Chili got a default against her. Now he's dumb and he moved for a default judgment against her, which obviously he lost because Piratini is still involved in the lawsuit. So what he should have done was just got the default against Kate and then proceeded with Piratini. Had Piratini also defaulted, had everybody defaulted, then he should have moved for default and at the same time a default judgment. It's, in fact, on California, it's on the same judicial council form. You know, it's request for, you check the box for default and either clerk's order or court's order, depending on which one you need. It's expected that if you get the default, you get the default judgment. So I don't know what this Blair Dunn guy was thinking. It doesn't make sense to me. He has not evidenced anything to suggest to me that he is experienced as a federal litigator or capable of writing good motions, capable of writing good pleadings, capable of properly assessing when to file a motion to recuse or for what reasons to file a motion to recuse, what the elements are to get an injunction or a TRO. It's like he hasn't shown me anything that he's a good attorney. Everything he has done suggests that either he isn't giving this case any of his Peter's. Thank you. I remember now. Everything he's done in this case either suggests that he is unmotivated, like maybe he's not getting paid, or maybe like if he's doing this as a favor to Springer and doesn't actually expect to win, he's putting he's putting more effort in than that doesn't make sense. Because like, why would he file these motions that he knows are doomed to failure? Like he's filing motions he doesn't need to file, but he's not putting the effort into the motions. So like, why file the motion if you know it's not going to succeed? But if you're going to file the motion, why not put the effort in to try to make the motion succeed? It doesn't make sense. It just doesn't make sense. It's like getting up at 3 a.m. to go fishing, and then when you get there, being too lazy to bait your fucking hook. You know what I mean? Like you're going through a lot of effort that you don't need to go through in order to lose. And if James is paying, which I don't think he is, but if James is paying, then why doesn't, like, you get paid by the billable hour. If James is paying, it would be an hourly rate. Either it's contingency or it's hourly. And if it's hourly, then you're getting paid to put the effort in. Why are you half-assing? Why are you not spending the time it takes to do the research, to review the facts, to make sure that you're applying the facts appropriately to the law to make sure that you get the outcome that you need? Or which would explain why he's filing motions. I mean, if he's getting paid to file the motions, then great, you file the motions to try to succeed. But then why are you not putting the time in on the motions? Like if you're getting paid to file the motions, great. You're also getting paid to do the research. You're also getting paid to write the motion correctly to win. It's none of it makes sense, which leaves the sole conclusion to me that he's a bad attorney. Now, I'm not saying he's a bad attorney. Don't sue me, bro. But I can't. My imagination is limited to the point where I cannot fathom another reason for what's going on. That doesn't mean another reason doesn't exist. Maybe he's trying to give an associate more time. Maybe somebody else is writing these things who has no experience in this matter, and he's just turned over control to him and just signing off on the pleadings. But even then, even then, if he's signing off on these pleadings, then that makes me wonder, like, he's responsible for them. If you're signing the pleading, you are taking ownership of that pleading. It's the whole federal rule of civil procedure. If you sign the pleading, if you file the pleading, if you later defend that pleading in court, you're taking ownership of it. You're responsible for it. So regardless of whether he palmed the motions off to a law student or whatever, it's his name on the signature line. Yeah, exactly. Like I have had a lot of motions. And yeah, in criminal, like one of the, it's actually a tactic that another attorney that I work for uses pretty constantly. He'll file a motion to suppress. Whether or not it's going to win, he'll file the motion. Because number one, it gets you another like pretrial hearing to see if everybody's ready to go on the motion. And then even another hearing maybe on the motion itself. So that gets you 2 more opportunities to negotiate with the district attorney. And if the district attorney at any of those times finds that he or she has a full plate and doesn't want to take the time and effort to defend the motion, you might get a better offer. The DA or ADA or whoever you're dealing with might be like, look, let's just make this go away. If your client does pretrial deferment, great, we'll be done. And so it's a useful tactic, even though the actual motion itself has no merit. As a bargaining kind of tool, I've seen it work. So, but you don't want to file something that just on its face is going to fail, and that's what this done is doing. Like I remember looking at the motion. It was at the end of the live stream. I looked at the motion. I'm like, this is going to fail. It's just going to fail. Like taking 10 seconds to glance at it. Like, you're not alleging all the facts. You're not laying out the facts for the court. You're not alleging any law. There was no citations to anything. And you're asking the court to grant an injunction after the court has already said no. And you're using a federal rule of appellate procedure in the district court. There's just nothing. There was just nothing there. And I mean, I don't even know why. Well, I guess I do know why defendants counsel responded to it, because they get paid to do it, and great. But man, it's just I don't see anything other than this Blair Dunn guy. Like, the only conclusion that I can imagine is that he's just really fucking bad at his job. That's all I can imagine. I'm not trying to talk shit about him, but he hasn't shown me shit. When I first saw the complaint, I was like, this fucker might have merit. James might be going places on this one. He might have been denied his procedural due process. He might. There's a very good possibility. There might be some other things in the New Mexico Code of Civil Procedure or Constitution or something that prevented the New Mexico judges from doing what they did. I was big on it. I was hopeful. But nothing in the complaint really solidified anything. And then nothing subsequently has made me think that this guy, Blair Dunn, is capable of taking this case to a conclusion that's favorable to Springer. So I'm going to call it right now that James is going to lose this, and he's going to lose this bad. And it's not necessarily because he had no case, but through James Springer's actions in saying publicly that he was spoliating evidence. In actually spoliating evidence, he's removed 2 of the videos that the court went to check on. His attorney's allowing him to do it, and his attorney is, for whatever reason, doing a shit motion in prosecuting the case. So I'm going to call it now. Springer is going to lose. Yeah, we're still talking about James. Furthermore, in ordering plaintiff to either file a motion for default or show cause as to why the case should not be dismissed for lack of prosecution does not evidence bias. It was simply the court's way of attempting to get plaintiff's counsel to do what she had done several weeks prior. Plaintiff filed returns of service indicating that all defendants were served on June 9th, 2023. Pursuant to the Federal Rules of Civil Procedure, defendants had 21 days until and including June 30, 2023 to respond to the complaint. Defendants failed to timely respond to the complaint. On August 7th, more than 5 weeks after the defendant's deadline to respond to the complaint, plaintiff filed an application for clerk's entry of default. On August 8th, the day after, the clerk entered default against defendants pursuant to Rule 55A for failing to plead or otherwise defend this action. Pursuant to Rule 55B, plaintiff was then required to apply to the court for a default judgment. However, he did not do so. Why? Who the fuck knows? But he got indignant over being told to. Instead, on August 10th, he filed his first notice of completion of briefing. 5 days later, on August 15th, counsel for defendants entered an appearance. And on September 5th, defendants had filed a response to the request for TRO/preliminary injunction. 9 weeks. 9 weeks have gone by. However, defendants did not respond to the complaint. Therefore, thereafter, plaintiff filed a reply in support of his request for TRO preliminary injunction. And on September 21, 2023, 11 weeks, the court entered a order denying the request for TRO preliminary injunction. As of that date, defendants still had not responded to the complaint, even though they'd entered an appearance over a month prior. Defendants later filed a motion to set aside entry of default. Plaintiff responded that he was unopposed to the motion, and on October 13th, the court entered an order granting the motion, setting aside the clerk's entries of default and instructing defendants to respond to the complaint. Consequently, on September 21, 2023, that's like 11 weeks after he should have filed his request for default judgment, the court issued an order providing plaintiff until and including October 5th, that was 2 weeks, to file a motion for default judgment or show cause as to why the case should not be dismissed for lack of prosecution. Not because the court is biased against plaintiff, but because the next logical step in the prosecution of this case was for plaintiff to file a motion for default judgment, the clerk having entered default against the defendants more than 6 weeks prior. So the clerk entered default 6 weeks prior, but it was 11 weeks after it should have been entered. Remarkably, plaintiff did not file a motion for default judgment or show cause for his failure to do so, but instead filed the instant motion for recusal. Yeah, like it does. None of it fucking makes sense. The guy is not doing a good job. Yeah, I hope the best. Like I don't have a problem with Springer. He does some things that I don't like, but him and I are actually closer together on his political beliefs than most people think. I don't know, man. Rev up those malpractice claims. Malpractice against an attorney, at least in California, is next to impossible to show. I don't know what it would take to show it in New Mexico. I don't think that what he's done so far has been malpractice, but you can reasonable minds can reasonably differ. Under these facts, the court finds that issuing an order instructing plaintiff to file a motion for default judgment or show cause why this case should not be dismissed for lack of prosecution does not give fair support to plaintiff's claim of bias and is therefore insufficient to support plaintiff's request for recusal. C. Henry, finding that issuing an order to show cause for a party's failure to follow the rules of civil procedure did not evidence any extrajudicial bias or prejudice and are therefore insufficient to support plaintiff's request for recusal. Because plaintiff's affidavit fails to assert that the undersigned judge's alleged bias arises from an extrajudicial source and contains no facts or reasons giving fair support to the charge of a bent mind that may prevent or impede the impartiality of judgment, the affidavit is insufficient and recusal under Section 144 is therefore unmerited. However, even if plaintiff's affidavit was sufficient, and it is not, recusal under Section 144 would still be unmerited because the certificate of counsel is deficient. So this is inexcusable. The certificate of counsel is insufficient. This is entirely under the lawyer's control. Entirely. Yeah. If you get past me yelling at him in the beginning that he doesn't get to fucking tell me what to do, if you get past that part, everything calms down and we actually have a fairly civil discussion. And yes, it was about 5 years ago. You can probably find it out there somewhere. Specifically, Section 144 requires the party's affidavit, quote, shall be accompanied by a certificate of counsel of record stating that it is made in good faith. Here, the certificate of counsel filed by plaintiff's attorney certifies only that plaintiff's, quote, motion to disqualify Judge Strickland is made with the utmost deference and with all benefit of the doubt possible in good faith pursuant to 28 U.C. Section 144. The certificate of counsel does not certify that the affidavit is made in good faith. I think he had his beard back then. I'll be honest with you. I think he did. And I don't think there's any video of it because it was a phone call or a Google voicemail or Google voice call or whatever it was. It wasn't a video. So you won't see either of us in it, I don't believe. So this is just inexcusable that Dunn fucked up this bad. Like entirely under his control. And he fucked up the basic thing of actually having a certificate of counsel that certifies the affidavit is made in good faith. Fucking crazy. It is therefore deficient, and for that independent reason, recusal under Section 144 is unmerited. See Watersheds denied a motion to recuse for failure to satisfy Section 144's procedural requirements because the certificate of counsel certified only the motion was made in good faith, but did not certify that the affidavit was made in good faith. See Armenian Assembly, that was the same. Sataki versus Broad Board of Governors, same. So there's a lot of stuff that supports this. Accordingly, the request for recusal under Section 144 is denied. Recusal under Section 455A. Pursuant to 455A, a judge of the United States shall disqualify herself in any proceeding in which her impartiality might reasonably be questioned. The basic test is whether a reasonable person, armed with the relevant facts, would harbor doubts about the judge's impartiality. There is as much obligation for a judge not to recuse when there is no occasion for her to do so, as there is for her to do so when there is. As with Section 144, the judge's bias must arise from an extrajudicial source for disqualification to be appropriate under Section 455A. However, recusal is appropriate even if the bias did not arise from an extrajudicial source, if opinions formed by the judge on the basis of facts introduced or evidence occurring in the course of the current proceedings or of prior proceedings display a deep-seated favoritism or antagonism that would make fair judgment impossible. Plaintiff's motion does not assert the court's alleged bias against plaintiff or in favor of defendants arises from an extrajudicial source. Rather, the motion appears to argue that the undersigned judge's alleged bias against plaintiff can be gleaned from her judicial rulings. However, as previously discussed, judicial rulings alone almost never constitute a valid basis for bias or partiality motion. See Cooley, observing that prior adverse rulings of the court will not ordinarily satisfy the requirements for disqualification under Section 455A. And the court finds the plaintiff has failed to identify any opinions or rulings displaying, quote, a deep-seated favoritism or antagonism that would make fair judgment impossible. The court further finds that a reasonable person would not harbor doubts about the undersigned judge's impartiality based on her, number one, sua sponte, providing defendants an extension of deadline to respond to a request for TRO 6 days after they first appeared in this case, and two, ordering plaintiff to either file a motion for default judgment or show causes why the case should not be dismissed for lack of prosecution 6 weeks after clerk entered default against defendants. Accordingly, the request for disqualification under Section 425A is denied. Therefore, it is ordered that it is denied. So, okay. Yes, that's essentially what they're arguing. They're arguing that the court should recuse herself because she is not biased in their favor. All right. And then we have and then the motion denying the injunction. The matter before the court, yada yada, having reviewed, it's denied. Relevant background. The events giving rise to the complaint are set out more fully in the court's amended order denying plaintiff's request for a temporary restraining order / preliminary injunction. Plaintiff is an independent investigative journalist who produces content intended to expose to the general public cases of government fraud, waste, and abuse. The complaint contains 2 paragraphs numbered 8. The court citation to 8.2 refers to the second paragraph 8 sequentially. Again, like that's like having 2 paragraph 8s is a minor thing. It is a very minor thing. However, when looking at the totality of the circumstances in this case, it is further evidence that Dunn is not spending the time or giving the attention to what's going on in this case. Or he's just really bad at his job. One of the two. I don't know. He's not. It's just compounding the showing that he's just lackadaisical. He's not putting the effort into it. And there's multiple of these. There's multiple redundant paragraph numbers. Plaintiff displays content on a YouTube channel he operates called James Freeman, which has approximately 444,000 subscribers. The content plaintiff posts on his YouTube channel and on other social media platforms often receives tens of thousands of views and frequently sparks robust debate about matters of public interest related to constitutional rights, the workings of government, and other related matters. On June 9, plaintiff filed a complaint for declaratory and injunctive relief, alleging violation of his rights under the First and 14th Amendments to the United States Constitution and Article 2, Section 17, 18, and 23 of the New Mexico Constitution. Plaintiff's claims arise out of interactions between plaintiff and personnel at New Mexico's 7th Judicial District Court, which resulted in an amended administrative order barring plaintiff from entering courthouse, blah, 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 blah. We've been all through this already. The court entered an amended order considering the request as one for a preliminary injunction, denying the request, finding plaintiff has failed to satisfy his burden of establishing a substantial likelihood of success on the merit of his claims. Plaintiff's motion wholly failed to identify the elements of his cause of action, much less demonstrate a substantial likelihood that the facts of this case satisfy those elements, nor did he cite any legal authority supporting his claims, which is grounds alone for denying the motion. A motion response or reply must cite authority in support of the legal positions advanced. Blah, blah, blah. And at least one court addressing similar facts has determined that restricting an individual's access to a courthouse due to disruptive behavior did not constitute a violation of the individual's First and 14th Amendment rights. See Me versus Gordon, which is out of the District of Oregon. See also Huminski versus Corsones, which is a Second Circuit case that said court, administrative, judicial, and other officials must at least have the ability to close a courtroom door to any person who they reasonably think may pose a threat to person, property, or decorum. A potential spectator may be excluded from a courtroom on a simple issue of propriety, reasonably unacceptable dress, unruly behavior, efforts inappropriately to communicate views in the courtroom, possession of personal property banned from the court, i.e. cell phones, cameras, or recording devices, and the like. No, indeed, he has not put his best foot forward. In his reply brief, plaintiff argues for the first time, you never raise arguments for the first time in your reply brief. You never. The only time you would ever raise an argument for the first time in your reply brief is to rebut something that the opposition raised. If you argued X, you have to support X in your motion. If they say X is wrong, but what about Y? Then you could raise an argument as to why Y doesn't apply. That's fine. But if you say X, but you don't support it, and then they say X is wrong, and here's all the arguments why, then you can't, in your reply brief, say, oh, X actually does apply, and here's all the arguments for. All the arguments for your position have to be raised. Mandatory in your moving papers. Because remember, it goes motion, opposition, reply. So the opposing party only gets one bite at the apple. You as the moving party have to make all of your arguments up front in support of your position. Then they rebut those arguments, and they might raise a new argument in opposition. And then you get to rebut that argument, or you get to rebut their positions and say why they don't apply. But you have to raise the argument in support of your motion in your moving paper. The defendant's actions constitute a, quote, prior restraint on the freedom of speech. Footnote number 3. Neither the complaint nor the motion characterize defendant's actions as, quote, prior restraint on speech. So that's a real fucking problem. And he is substantially likely to succeed on the merits of his claims because, quote, any system of prior restraints of expression come to the court bearing a heavy presumption against constitutional validity. However, assuming arguendo that this argument is properly before the court, and citing this particular case, Reedy, where a party waives issues and arguments raised for the first time in a reply brief, so it is not properly before the court. But assuming, for the purposes of argument, that it is properly before the court, plaintiff cites no authority supporting his argument that defense actions in this case constitute a prior restraint on speech or expression. What counsel did is he essentially pulled a Chile de Castro. Instead of showing that this is a prior restraint on speech, he simply states, this is a prior restraint on speech, and that's it. It's just terrible. Neither the administrative order, the amended administrative order, or the order excluding presence of Chief Judge, this is really hard for me to read. I should probably sit up. I'm in a recliner chair, though. Neither the administrative order, the amended administrative order, or the order excluding presence, Judge Murphy's act of excluding plaintiff from the video teleconference hearing, nor Ms. Rossengall's alleged act of refusing to serve plaintiff in the clerk's office actually restrain plaintiff's speech or expression. Rather, they restrain his access to court hearings and files. Plaintiff has cited no authority, binding or persuasive, holding that restricting an individual's access to court hearings and documents constitutes a prior restraint on speech or expression in violation of the First Amendment. See Gannett finding that an order excluding the press from a courtroom, quote, differs substantially, end quote, from a, quote, gag order, end quote, prohibiting the press from publishing information already in their possession, which is a, quote, classic prior restraint, end quote. So the court is actually, pointing out that that Dunn is not actually even correctly identifying a prior restraint. I can hear those fucking guinea fowl in here. Jesus. And citing application of NBC, this is not a prior restraint case. NBC is not restrained by the district court order from publishing or broadcasting documents or information in its possession. Rather, the case concerns the right of the public and representatives of, quote, the media, end quote, to have access to documents filed in a district court at the preliminary stages of a criminal prosecution. See also Cianfrani, finding that limiting the media's access to a pretrial suppression hearing did not constitute a prior restraint on speech and did not violate the First Amendment. And that's really annoying. So I'm going to sit back again. I'll have to struggle with my poor eyesight because I'm getting old. For these reasons, plaintiff has failed to carry his burden of establishing a substantial likelihood of success on the merits of his claims. C. Van Dyke, finding that plaintiff failed to show a substantial likelihood of success on the merits, where he offered only conclusory allegations and cited no case law in support of his claims. Doesn't that remind you of Chile, though? Conclusory allegations in support of his claims? No case law in support of his claims? Like citing case law, maybe, but in support of his claims? No. And this guy is an attorney who founded a law firm. He's a founding partner of a law firm that specializes in federal advocacy. I mean, is this a case similar to Chile's being a 20-year law scholar? Is this just an allegation that he's making? Because plaintiff failed to establish the likelihood of success on the merit, court must deny his motion. Plaintiff's failure to prove any of the four preliminary injunction factors renders its request for injunctive relief unwarranted. See Sierra Club, a party seeking a preliminary injunction must prove that all four of the equitable factors weigh in its favor. Plaintiff has appealed the court's amended order. On September 29th, the plaintiff filed the instant motion for stay and injunction pending appeal. Defendants filed a response. Plaintiff filed a reply. Discussion. Plaintiff moves pursuant to FRAP 8A Again, why the fuck would you move under the federal rules of appellate procedure? If he was filing a motion in the Court of Appeals to stay the matter in the lower court, great. But even then, you still have to apply at the lower court, at the district court level, for that injunctive relief. And then if it's denied there, then you could ask the Court of Appeals to enjoin it from the appellate level. Fucking stupid. He moves pursuant to FRAP 8A for stay and injunction pending his appeal. The court's amended order denies the request for a TRO/preliminary injunction. Defendants argue the stay and injunction pending appeal are unwarranted under FRCP 62C, which is the correct one that he should have moved under. FRAP 8A, like, oh my God, like, it's just so annoying that an attorney is doing this. That an attorney who, quote, specializes or his firm specializes in federal advocacy. Like he makes attorneys look bad. This dude makes attorneys look bad. Maybe he's great in other cases. Maybe in agricultural cases or farm cases, maybe this guy is stellar. Maybe this guy is the go-to guy. I don't know. But in this particular case, he is fucking terabad. Just absolutely unmitigated terabad. I'm not saying that the defense counsel is any better, but defense counsel so far, well, not asserting judicial immunity. Jesus Christ. Oh, what are they doing with attorneys in New Mexico? Never mind. Defense counsel is just as fucking bad. But at least they got FRCP 62 as the correct. I mean, so because the court could have been like, okay, so you're arguing under federal rules of appellate procedure 8A, but it's actually what you should have argued is under FRCP 62C. And so I'm just going to do the analysis under FRCP 62C, and maybe he would still have won, right? So, but fucking Christ. Well, I'll let you do that. You know how to use LexisNexis and Pacer. You go ahead. You track those down and send them to me, and I will go over them. How about that? FRAP 8A governs motions for stays and injunctions in the United States Courts of Appeal, while FRCP 62C governs motions for stays and injunctions in the United States District Courts. Under both rules, however, the factors regulating the issuance of a stay and injunction are generally the same. Whether the stay applicant has made a strong showing that he is likely to succeed on the merits, you lose right there. Whether the applicant will be irreparably injured absent a stay, you lose there. Whether an issuance of the stay will substantially injure the other party's interest in the proceeding, you lose there. And where the public interest lies, you lose there. So he loses in every single one of them, but those are the factors. The movement bears the burden of proving these four factors. The burden of production and persuasion is with movement. It is the movement's obligation to justify the court's exercise of such an extraordinary remedy. Because the burden of meeting the standard is a heavy one, more commonly stay requests will not meet the standard and will be denied. The movement must address each factor, regardless of its relative strength, providing specific facts and affidavits supporting assertions that these factors exist. And what did our erstwhile attorney do? What did Mr. Dunn do? He did fuck all. That's what he did. He did fuck all. The party requesting a stay bears the burden of showing the circumstances justify an exercise of that discretion. I'm getting a little heated, and I apologize about that. I apologize for getting a little heated about this. It just really irritates the shit out of me when a professional performs this poorly. Like if you go to a backyard mechanic, your buddy down the road who likes to tinker on his car on the weekends. If you go to him to do an oil change or whatever, and he forgets to put the bolt back in your oil pan, right? And so And so he pours the oil in and it just goes out. You're going to be like, whatever. This, we've been drinking beers while he's been helping me out for free. It's not a big deal. But if you go to an actual like licensed mechanic with his own shop, you're going to expect a certain level of performance, a certain level of service. You're going to be a little bit more critical of him, right? So I am much more critical of people like Blair Dunn and people like opposing counsel in this case than I'm going to be of Chili or whoever Chili's having write motions on his behalf. And it's not because I like Chili. It's because Chili's a fucking idiot. And he doesn't have a law license, right? He hasn't gone through the training. He's not holding himself out to be some sort of a specialist in federal advocacy. This Blair Dunn guy, like he took this case representing that he was qualified to do it. And what have we seen? A bad plaintiff will make for bad law, right? But a bad attorney will also make bad law. And is this what we want? Is this what anybody wants? Like this shit can come, like, even if you're anti-auditor, even if you're anti-Springer, like this shit can come down bad, like in all sorts of ways. It could generate bad case law in all sorts of ways. Now, luckily for us, this judge appears to be very competent. I have no issue with what this judge is doing. This judge has provided well-reasoned, seemingly unbiased orders that seem balanced and fair. And it does, like, despite all the shitty language that Dunn uses, all the accusatory language that Dunn uses, this judge still seems to be keeping it together and not retaliating or lashing out. So this judge seems like she's going to be a good judge. I hope she doesn't disappoint me. John, you're such hubris. Well, everybody makes mistakes. Even judges make mistakes. That's why there's courts of appeal. Even I make mistakes. The party requesting a stay bears a burden of showing that the circumstances justify an exercise of that discretion. The 10th Circuit requires the applicant to address these factors. Plaintiff's motion wholly fails to identify these factors, much less apply them to the facts of this case, or otherwise address, analyze, or prove them. Yes. This is 100% correct. Indeed, plaintiff's motion, which is brief, is entirely devoid of legal or factual analysis. That is correct. Like you see motions like what he's doing in family law, in courts of equity, where basically the court will fill in the facts or will fill in the law for you. Like if you don't know and you just plead the facts, like in family law, at least in California, you don't have to provide a memorandum of points and authorities. You just allege the facts. Now, there is an art and a science to knowing what facts to allege and how to frame the facts to best assist your client. But you don't have to provide a motion of points and authority or a memorandum of points and authorities, a memorandum of law, depending on how you want to phrase it. But motions in the federal courts, you have to provide that memorandum of points and authorities. You have to give the facts, give the law, marry them together, and present them to the court. It doesn't matter if you're doing agricultural law or farm law, or in this case, a civil rights lawsuit. A motion has to. This isn't equity that we're asking for here. This is a legal matter. So you have to give the facts, give the law, apply the facts to the law. Basically, you have to hold the court's hand and walk the court through the steps to get to the point where the court is going to grant the motion in your favor. That's in state courts, in all civil matters. You got to do a memorandum of points and authorities with your motion. In all discovery motions, you have to do a memorandum of points and authorities, even in family law. It's frustrating that an attorney didn't know that he had to provide a memorandum of points and authorities. As such, it is subject to summary denial. Plaintiff cites the factors for the first time in his reply brief and argues that because the court denied his request for a preliminary injunction based primarily on its failure to establish a substantial likelihood of success on the merits and not on its failure to establish the other three factors, the court should grant the stay an injunction pending appeal. However, the court waives issues and arguments raised for the first time in a reply brief. But even this, the court doesn't even harp on this, but even this, like the court said you lose on the substantial likelihood of success on the merits. And what are the four factors that you have to prove? The four factors that you have to prove are: one, whether the stay applicant has made a strong showing that he's likely to succeed on the merits. And he has to prove all four of them. All four of them. So even in his deficient and devoid of facts and argument moving papers, even there, he still manages to get the law wrong in his reply brief. He still managed to get the law wrong. Yeah, I totally lose on one of the four, but you should grant it because I win on the other three. I'm not going to tell you why I win. I'm not going to tell you how I win, but I win on the other three. But you have to prove all four. Oh, fuck me running. I'm sorry I'm getting heated on this. Like, it's just, like, Stone Vet, Josh, he gets heated when fucking idiots are shitting on or saying stupid things about service. Like when that weapons douche canoe or KFAR are listening to the absurdities and lies being spouted by Wrangler and not saying anything. And Stone Vet just gets heated and like, oh, these fucking M&M heads, right? That's kind of where I am right now. Like this guy, he holds himself out to this is it. This is his fucking bread and butter. Federal advocacy is his bread and butter, according to him. And he fucking fails his heart at it. And even in his in state practice for farms and agriculture, even there, that would be civil. And civil matters, every motion you make has to be supported by a memorandum of points and authorities. It's not equity. When you're dealing, there's equity and there's law. Equity is where you get some relief other than money. So a motion for a restraining order, et cetera, would normally be equitable relief, but you'd have to, because you're not doing it in family law court where they want, at least in California, family law court's different because they want people to be able to do it on their own. They want people not to have an attorney. So they make it pretty simple. They say, basically, just give us the facts and we'll deal with it, right? But equity is where you're not asking for money damages. Law is where you're asking for money damages, essentially. That's the easy form of it. But again, in his farm and agriculture work, he would be required to do a memorandum of points and authorities on all of his motions. He would be required to do that. So why didn't he do it here? Because plaintiff's arguments are devoid of the factual and legal analysis necessary to establish its likelihood of success on the merits, plaintiff has clearly not met its burden. Clearly. See also this case denied motion because in Aurelia, it does not include any substantive legal argument. See also this case, recommending the district court deny an emergency motion for TRO, which was less than 1 page long and is, quote, utterly devoid of an analysis of the relevant factors. And then the report and recommendation was adopted. And see also this case, denying a motion as, quote, conclusory and devoid of any legal or factual analysis. The motion is also subject to denial because it, like plaintiff's request for a TRO preliminary injunction, cites no supporting authority. A motion response or reply must cite authority in support of the legal positions advanced. This is a fancy way of saying you've got to do a memorandum of points and authorities. That's what it's saying. You've got to use a memorandum of points and authorities. Deny a motion for failure to cite any supporting authority in violation of local rule, blah, blah, blah. Plaintiff's failure to cite authority supporting his position, quote, suggests either that there is no authority to sustain his position or that it expects the court to do his research. The court declines this invitation. It's therefore ordered that plaintiff's opposed motion for stay and injunction pending appeal is denied. And rightfully so. And I fully don't expect I fully don't expect him to have any chance of success on his appeal. It's a waste of time and money. I hope that Springer isn't paying for it. I hope that Dunn is paying out of pocket, because at least if Dunn is paying for it, then he's the only person who's basically suffering his ignorance and foolishness. Now we have a motion to amend and correct. And let's see what this one is. I downloaded it today, but I have not read it. Plaintiffs opposed motion for leave to file an amended complaint. Counsel for defendants has been consulted and does oppose amendment of the complaint. The court will likely grant this. I haven't read it yet, but just from the get-go, the court is very likely to allow one amendment of the complaint. We've seen it with Chile. The court is going to give a lot of benefit of the doubt. But I haven't looked at this yet. Let's see if he actually analyzes the facts and the law. Let's see if he provides us with a memorandum of points and authorities. Background, which is a good start. Plaintiff's complaint was filed June 9th. Plaintiff seeks to amend the complaint to additional. Fuck me. Plaintiff seeks to amend the complaint to additional facts of violative actions undertaken by the defendants to support the existing counts in the complaint and preliminary injunction relief. Plaintiff seeks to amend the complaint to add additional facts. I don't know, like, fuck proofreading. I mean, what document? Show me one fucking document that Dunn has put out that has not had fucking mistakes like this. Show me one. Show me one. Oh, fucking, this guy's a fucking, drives me nuts. Specifically, the Fifth Circuit has recently held that I thought this was, is New Mexico Fifth Circuit? I don't think, New Mexico's not Fifth Circuit. New Mexico's Ninth Circuit, right? New Mexico, Ninth Circuit? Or is it 10th Circuit? It's got to be 10th Circuit then. Let's do this. Let's do it this way. Yeah, it is 10th Circuit. Okay. But it's certainly not the fucking Fifth Circuit. So why are we looking at 10th Circuit or Fifth Circuit cases? Who the fuck knows? To be sure, this modifying injunction still, quote, restricts governmental communications not specifically targeted to a particular content posted by plaintiffs themselves as the officials protest. This modified injunction still, quote, restricts government communications not specifically targeted to particular content posted by plaintiffs themselves. Okay. My what the fuck meter is going off the charts. So it's currently there's a petition for certiorari that's been filed on this particular case, and it may since it was distributed for conference on 11/3, it may already be granted or denied. So this citation is very fucking suspect. Very fucking suspect. Let's see. Let's go to Scholar. We're gonna do this. Copy. Paste as plain text. All right, what are we looking at? So, okay. This is a challenge to Biden's mandate that federal employees get something against the COOF. All right. So it doesn't seem particularly on point. To be sure, this modified injunction, quote, still restricts government communications not specifically targeted to the particular content posted by plaintiffs themselves. So what the fuck is he arguing here? But so what communication is he trying to get enjoined by the government officials in this particular case? He's not trying to get anything enjoined by the government officials. So I don't know what the fuck. Like this seems completely inapposite. That is not so why so and the court has not held that the particular injunction requested by plaintiff in this case, in Springer versus the 6th Judicial District or 7th Judicial District, whatever it is. In this case, there's no holding of overbroad. Why are we looking at this? Why are we looking at this? Holy Jesus Christ. He says certiorari granted. He says that certiorari has been granted. I didn't see that certiorari has been granted. I mean, maybe it has, but I didn't see that. Here, the allegation made on information and belief is that defendants or employees of defendants acting on their behalf would have engaged or have engaged in a campaign to have Mr. Springer's content suppressed by the social media company YouTube. Is this the allegation they want to add? They want to add an allegation that defendants have engaged in a campaign, whatever the fuck that is. That's not a fucking fact. That's not a fact. Engage in a campaign. That's not a fact. To have they called YouTube and filed a privacy strike on plaintiff on this date at this time. YouTube took down the content on this date at this time. Those are facts. Saying like this is a chilly fucking fact. This is a chilly fact. They've engaged in a campaign to have his content suppressed. That's a fucking conclusion, not a fact. Why the fuck are you this retarded, Mr. Dunn? I am not an alcoholic and I am not a fan of day drinking. But content like this makes me want to day drink. This would be so much more pleasant if I was drunk while I was reading this. Because then I'd just laugh and laugh at how fucking stupid it is. There is clearly no futility to Mr. Springer's additional claims. What claims? Because if proven true, they support the injunctive relief he seeks, and the declaratory relief the defendants here have engaged in additional unconstitutional action beyond those already pleaded. He's trying for another bite at the apple. So what he's doing is he's trying to amend his complaint to get another crack at the injunctive relief that the court treated as a motion. They treated as a motion. Well, I hope it doesn't affect your performance in bankruptcy court, sir and or madam. He had an obligation to bring all of the relevant facts to bear in his initial motion for injunctive relief. He did not. And so this is a weird fucking workaround that he's trying to do. If he was just trying to amend his complaint to plead more facts in support of his substantive allegations about violations of 42 USC 1983, etc., that wouldn't be a big problem. That would not be a big problem. But he's trying to do it because he's asking for injunctive relief. And so that ship is fucking sailed, bro. The court is not going to treat this as a new, renewed motion. And so there's a thing called a motion for reconsideration in state law. Technically, it doesn't exist in federal courts, but there's two ways essentially that you can do what the federal courts will treat as a motion for reconsideration. Let's not get into the weeds on that. But the important thing is that you can't just try to get another shot at it. This is essentially his motion for reconsideration. He wants to file a motion for reconsideration. But in a motion for reconsideration, you can't allege facts that you knew and should have alleged the first time. You can't do a motion to consideration to argue law that existed at the time. Like a motion for reconsideration is where you get facts that you could not have known at the time that you filed the motion, right? Facts that you could not have known. Like a new witness showed up out of nowhere that you've been trying to get, and you could document that you've been trying to get that particular witness, and you've served subpoenas or you try to serve subpoenas, and you could document that you made every effort to get that information from that witness prior to filing this particular motion, but you couldn't do it. So you filed the motion based on the facts that you had, and then the witness turns up. Well, then maybe a motion for reconsideration is warranted at that point because there might be new facts, right? There's new facts that I could not have alleged in the initial motion. New law. New law doesn't mean that law that you didn't find. It means like, hey, you know what? The Court of Appeals just came out with this particular decision that says, you know, in this situation, I actually win. And so that would be fine, right? That would be fine where you file a motion for reconsideration based on new law. It's new facts or new law. If you don't have new facts or new law, then basically you're spitting in the wind. It's just going to blow right back in your face. And what he's trying to do is he's trying to do a motion for reconsideration with no new facts that he should not have other. He's not saying that I couldn't have pled this originally or that I couldn't have pled this in my motion for injunctive relief. What he's saying is that I didn't. And I want another shot at basically it's a motion for reconsideration alleging facts that I should have alleged in the initial motion. That's what he's doing. And it's stupid and he's going to lose. And I don't know why he's doing it. And it's frustrating to me. Number 3, refusing leave to amend is generally justified upon a showing of undue delay, undue prejudice to the opposing party, bad faith, or dilatory motive. Failure to cure deficiencies by amendments previously allowed, or futility of amendment. Now, the court is probably going to allow him to amend, but will not take up the motion for injunctive relief. I would guess. I would posit. But the injunctive relief, that ship has sailed. You need to fucking appeal it. I think he already is appealing it. So he is appealing it, right? He already is appealing it, right? So he's already appealed it. So there's a pending appeal. There's a pending fucking appeal on the matter that he is concurrently trying to essentially do a motion for reconsideration for. Against the Wind, I think, is the Kansas song. Running against the wind, not spitting into the wind. Speaking of which, speaking of orange cones, who I adore, I have ordered a noise canceling microphone, and I'm going to do another fish room tour, not live stream, because the video quality on live stream was fucking terrible. And I don't know why, but I'm going to do a tour of my fish room because I've got a bunch of planted tanks now that I'm I'm personally very impressed with. I think I've really fallen in love with planted tanks. Boy, I tell you what. But I'm going to do another fish room tour with good video, like high definition video, hopefully, and with good sound, the noise canceling mic, and we'll see how that works. I do love my veggies. All right. So back down to this. We were on page 3 or page 2 of 3. Plaintiff seeks to amend the complaint to add additional cause of action to this matter and request damages for the alleged constitutional violative conduct of defendants. So the one case he cites is inapposite. The one case he fucking cites, this right here, is not applicable. I guess technically he cited this case as well. So we'll see, I guess. He doesn't really lay out any facts. He doesn't actually go through any of the argument as to why it's not undue delay, why it's not undue prejudice, why it's not in bad faith, why there is no dilatory motive, why it's not failing to cure deficiencies by amendments previously allowed, and why the amendment isn't futile. And I have a feeling, well, I don't know, because defense counsel seems pretty fucking bad themselves. They should harp on the bad faith or dilatory motive, and they should harp on the futility of the amendment, at least insofar as it relates to the injunctive relief. Words are hard. All right. And then third it. So Blair Dunn signed it and Zach Cook signed it. Jared R. Vander Dusen was smart enough to not sign it, apparently. A special place. He got his license in 2019. He's been practicing law for less than I have, and I'm only a first-year family law attorney. Nope, I will not. He lost in the Republican convention with 7 votes, 5.8% of the vote. So this guy might be who's actually writing him. And then Blair Dunn is just signing him off. But again, it's Blair Dunn's responsibility. He is the one who is taking responsibility for all of this. Don't mess around with Slim. That was bad. That was dumb. Present. Share screen. And we're going to do... I hit the wrong button. What happened? I am mostly retarded. All right. So I don't even know if I want to go through the proposed amended complaint. That's what I meant to hit right there. And here's the proposed amended complaint. He put it in red line mode. Oh my God. Track changes mode. Fucking hell. Oh, I hate you. There's a special place in hell for people who do this. Okay. Okay, so he's still seeking the permanent injunctive relief, but he's no longer seeking the well, here's a real fucking problem. Here's a real fucking problem. Oh my God. What happens to the appeal for denial of the TRO if they amend their complaint to no longer ask for the TRO? Just like with Chili, just like in Chili's case where he amended his complaint and he filed an amended complaint that didn't have the initial causes of action, like in DeCastro versus Abrams. His first amended complaint had these causes of action for things like defamation and whatnot, right? The first amended complaint took out all of those and replaced it with violations of the Copyright Act. And so all the other causes of action gone. In DeCastro versus Wagner, in his one of his amended complaints, he took out all the allegations against, I'm going to say, the city of Ironton. He took allegations, no, against the county. He took out his allegations against the county, right? And the court's like, hey, well, you amended your complaint to remove them, and you never amended the complaint to put them back in, so they're fucking gone. You waived them. In this case, holy shit. In this case, if this fucking moron, pardon my French, if this fucking moron amends his complaint to remove the TRO, his appeal is fucking gone. Now, I'm not saying he's going to win his appeal in the first place. It's a fucking loser. I'm not saying he's going to win. But Jesus fucking Christ, like, how incompetent, like, there's no fucking race to be first to the most incompetent. This isn't a competition to see how incompetent you can fucking be. If you are doing the same shit that Chili fucking DeCastro is doing as a licensed practicing attorney, if you are doing the same fucking shit that Chili's doing, what the fuck is wrong with you? What the fuck is wrong with you? Holy shit. Oh, this is fucking hard, dude. This is fucking hard for me. This is fucking hard for me to get through with how incompetent. It seems like he's actively incompetent. It seems like he's trying to be incompetent. Allegation 8. Allegation 8. Even the fuck after it's pointed out that there's two numbered 8s, is he going to correct it? Fuck no, he won't. Fuck no. Why the fuck would he? Why the fuck would he do something as simple as make sure that his numbering is fucking correct? Look, there's 2 9s. Here's number 9, and here's number 9. Why correct it? Why fucking even correct it? I wonder, are these links going to stay up and stay active? Are they going to stay active? Or is he going to fucking pull them down? I don't fucking know, dude. I don't fucking know. Like, I am not against Springer in this particular action. Like, I'm not actively against Springer. But oh, Jesus fucking Christ. I'm pretty sure I'm telling you exactly how I feel. Pretty sure I'm telling you exactly how I feel. All right. On October 31st and November 1st, plaintiff entered the public areas of the Torrance County Courthouse facility in full compliance with the 7th Judicial District Court's administrative orders at issue in this matter, and made several videos as part of his reporting and as expressive conduct. See these 2 videos. All right, we're going to go up to, was it this one? So what are the orders? The orders that he's banned from entering the Torrance County District Court unless appearing for a hearing or having specific court business, i.e., doing something that the court wants him to do, like the court is there for, like filing a complaint, filing an opposition to a complaint, filing a petition for TRO, paying court fees, court fines, whatever. That's the business of the court. That's the court business. The court business is not making videos as part of his reporting and expressive conduct. In retaliation for plaintiff's reporting, October 31st and November 1st, and this was so this was filed February 28th. So no, it wasn't in fully, it was not fully in compliance. Yes, he is prohibited from going into the courthouse unless, number one, he is there to appear at a hearing, or number two, he's there to do business that the court is there to do business for. So yes, he is absolutely prohibited from going to a public hearing. And as we've seen from the cases that the district court cited, that is fully acceptable. And I would have expected it to be fully acceptable. In retaliation for plaintiff's reporting and protected speech contained in the first video noted in the paragraph above, upon information and belief, the defendants or employees of the defendants acting at their discretion conspired to have YouTube censor plaintiff's video, resulting in the following. What facts are there? What facts are there? See, conspiring is not a fact. Conspiring is a conclusion. They talk to each other specifically about having his video taken down for privacy strike, right? I guess, I don't know. But it's not a fact. So resulting in this. So he got a spam, deceptive practices, and scams complaint. This type of government action, what? Conspiring? What YouTube does is not, as so many people like to say, governed by the First Amendment. The First Amendment does not protect you from actions by YouTube. It's not because of his political leanings and reporting. It is because he's disruptive. They've not, nowhere in any of their documents have they mentioned his political leanings or his reporting. They've mentioned him violating court orders, i.e. the then existing policy on wearing a face covering, the current existing policy on having a cell phone in the courtroom, the current existing policy against recording in the courtroom, him being disruptive with Bennett and arguing with him, his being disruptive with the court clerk and calling her a fucking whore or a prostitute. I mean, Michelle, unless it's your position, and you can correct me if I'm wrong, unless it's your position that going around calling government employees prostitutes because they're noting that you're not complying with an existing court order Is that a political leaning or is that reporting in your estimation, Michelle? This type of government action is violative of the rights protected by the United States and New Mexico constitutions and is precisely the type of conduct the, again, Fifth Circuit has moved in, has affirmed to warrant preliminary injunctive relief in Missouri versus Biden. No, it is not. It is not. It is not. In Missouri versus Biden, there is no mention of YouTube. There is no mention of making complaints to YouTube about content, which he can't even fucking establish in the first place. He can't even fucking establish it in the first place. He has on information and belief they conspired. What they say, how they say it, where they say it, when they say it. Oh, we got no facts. This is literally just him saying, post hoc, I got this strike, ergo propter hoc. They must have complained about it. And they must have complained about it in their official roles. If that clerk who he called a prostitute, if that clerk went to YouTube and said, I want this video taken down because he's literally calling me a prostitute in it. If YouTube takes it down because of harassment, why would you say that that's the government doing a First Amendment, restricting your First Amendment activity? It's like when this is literally like when these fucking idiots say you can't solicit a trespass. It's literally like these fucking idiots saying you can't solicit a trespass, that the government can't ask a private actor if they want to do something or not do something. It is literally the same thing. Literally. Can the government, quote, solicit, end quote, a trespass? Yes. The cop can say, hey, did you want to trespass this guy? And that's not violating any of your fucking rights. Can a government employee say, hey, this fucking video is harassing me, which the strike wasn't even for harassment, so I don't even know what the fuck they're talking about. They're saying it's spam, deceptive practices, and scams. And how fucking lazy is this? This is an email. Where's the full fucking email? What date did he get this? We don't know. We don't know. Where does it show who it's from? We don't know. Where's the rest of the email? Not here. What a fucking shit show. Plaintiff has been able to successfully appeal actions Plaintiff has been able to successfully appeal the actions to censor speech and press, but upon information and belief, understand the defendants will continue to undertake these actions to censor plaintiff's reporting and speech unless enjoined by this court. So YouTube took the video down. He appealed it. They put it back up because they said they found that it didn't, in fact. So where is the fucking harm? What are the government agencies going to do? See, they're judges. You might not understand this, but they're judges, and they could do things. They could do things like they could have administrative orders issue. They could have an administrative order issue to YouTube enjoining YouTube from posting those videos. That, my friends, that would be a First Amendment violation. That's what it would be. But saying, hey, YouTube, even assuming arguendo that one of these named defendants did this, which he doesn't even say it's a named defendant. He doesn't even say it's a named defendant. the defense or employees of the defendants. Well, so what? Some employee of the 6th Judicial District Court, like, fucking just. I'm sorry. Discrimination. Let's see. Nope, he doesn't add any facts or law. Doesn't add any facts or law. Hey, look, he can figure out how to start renumbering. 33. Oh, wait, he can't, because then we're back to 30, 31, 32, 34. Like, why the fuck wouldn't we? Why the fuck wouldn't we? Counting. How does it fucking work? How does counting work? I have made it through all. I have a high school diploma. I have gone to college. I have graduated from college. I have graduated from college with grades sufficient to allow me to get into law school. I've gone through law school. I've graduated from law school. But counting, fucking counting, numbers under 100 escapes me. How the fuck does counting work? Holy fucking shit. Holy fucking shit. Oh, and then the court has basically said, look, like, you don't have sufficient grounds to prevail on your injunctive relief. Your odds of success, your chance of success on the merits, because when the court is looking to grant or deny the temporary restraining order and or preliminary injunction, the court is looking at your end goal chance of success on the merits. And the court said you're unlikely to prevail on your chances or on the merits because you haven't alleged sufficient facts. You haven't alleged sufficient law. Michelle, you look like a retard trying to defend Springer in this. Okay. The requirement for face covering was done by the New Mexico Supreme Court, had nothing to do with James. The rules, the orders against having the cell phone in the courtroom and recording in the courtroom predated any of this significantly. You're pissing up a rope, Michelle. You're not going to get anywhere with this. The order was specifically directed to Freeman after he violated existing court orders. Now there's a new one specifically for him, so the court can hit him up with assuming service is correct, which he doesn't fucking allege. He doesn't even allege. Like Christ. He doesn't address any of the fucking failings of his initial complaint. So anyway, that's it. That's it for today. That's the last of it. I don't think there's anything else in any of these particular cases that need to be covered. That was the motion to amend or correct. Wallace still, I don't believe, has any filing to clarify. We'll see how that goes. De Castro versus LVMPD still hasn't changed anything since the last time I covered it. This is the De Castro versus Wagner appeal. Again, hasn't really changed substantively. The attorneys are just making their appearances. So unless there is something coming forward with questions, yes, that's exactly it, Captain Clown. The New Mexico Supreme Court invented time travel and sent a T-800 into the past to create rules to keep Springer from winning. Yes, that is exactly it. So thank you for watching. Have a great day.